All right, and we are live. Thanks everyone for tuning in today to the Late Night Legal Podcast. It's currently 7:34, July 9th, 2020. I awoke today to some more news coming out of the Supreme Court of the United States, oftentimes referred to as the Scotus. There are really a huge number of important cases that were published in this last week. Let me adjust my microphone really quick. And I really wanted to get something out of my review of the cases this week. I've today probably read over 400 pages of Supreme Court decisions, and I'd like to go with some overviews of the cases. So I'll give just a general format of what's going to be happening. I'm going to talk about some general aspects of the case. I'm a practicing attorney. I went to Washburn University School of Law. I've been practicing law for 5 years. And so I'll be interjecting while I'm going over many of the court decisions, facts, legal precedents, some of my practical experiences and feelings towards the general rulings. In addition to that, I will be going over what I think some of the implications are for a lot of the cases that are going to be the cases that have been pronounced are going to have a lot of future implications. And so I'll be covering what I think those future implications are. But before we get formally started on my analysis, just have to say, general disclaimer, as any good lawyer would do, is that this is not to be construed as any form of formal legal advice. If you need legal advice or an attorney, please seek out an individual attorney for an consult. Each individualized case is different, so this should be just used as a reference guide or perhaps for basic information based on recent Supreme Court decisions and should not be construed as formal legal advice. I'm not your attorney unless we enter into a specific signed agreement, and if at any point you want to reach out to me, feel free to do so. Now that is out of the way, let's go ahead and get started on the fun, nerdy aspects of what's been going on this week. There have been all over the place decisions. We've had some good decisions. We've had some kind of surprising decisions. And there's one decision that I'm actually going to start with today that I think has gone under the radar, that had it been decided differently, and it was a narrow decision, it would have had huge ramifications for everyone. And this one's kind of gone under the radar because of the other more politically aggrandized information that's come out from some of these decisions. So this week in review of the Supreme Court, let's go. It's the first case that we're going to talk about is Barr, who's the Attorney General of the United States for the federal government, et al. Versus the American Association of Political Consultants, Inc. Now, this case is one that is the case that hasn't really been talked on as much, and it has to do with robocalls. We all know the infamous robocalls that we get, and in the early 90s, when I was just a wee lad, people used to get them much more prolifically. This case deals specifically, it's in response to consumer complaints. Congress passed what's known as the TCPA, or the Telephone Consumer Protection Act of 1991, which prohibits essentially all robocalls to cell phones. Now, that legislation was passed in 1991. That was a modification of the 1934 Act, and it was modified again in 2015. So 2015, Congress amended the robocall restriction, carving out a new government mandate exception. So essentially, if you owe the government money, if you have a form of government debt, whether it be through student loans or federally backed mortgages or a loan through the Veteran Affairs, then they essentially carved out an exception to the rule. So the rule is robocalls are illegal, generally speaking, specifically to cell phones. That's what this case deals with. And the government says, okay, well, we have a immediate public concern with fiscal responsibility. So in order to deal with our national debt, the rising deficits that we have each year, year to year, which there's difference between deficits and debt. In order to deal with the overall debt or the yearly deficits, we want to have a new mechanism in order to increase our ability to collect. So we want to be able to make robocalls, but private individuals cannot make robocalls to collect debts. Now, the petitioners in this matter, which is the original filers, which is the American Association of Political Consultants, actually aren't interested in making debt collection calls. They want to make robocalls similarly to what the government's doing, but they want to do it for essentially political action purposes. So they want to be able to call you, have an automatic recording that calls you and says, hey, we represent a certain political organization. We would like you to donate money to this political organization for a specific reason, whatever that reason is. Now, the district court determined that the robocall restriction with the government debt exception was content-based, but it survived to strict scrutiny. Now, in order to give a little backdrop as to what that means, the government oftentimes, and I have published a previous video talking about First Amendment rights, and that the First Amendment essentially says Congress shall make no law infringing on the individual right to free speech. Now, that does come with some exceptions. There are actually entire classifications, which I'll talk about a little bit later, on what forms of speech are prohibited, essentially aren't covered by the First Amendment, such as its obscenity or speech in association with the commission of a crime. That's actually not considered something that's protected by First Amendment. It's essentially exempt from First Amendment. There's also what's known as time, place, manner restrictions. These time, place, manner restrictions have to survive a certain form of scrutiny. So there's essentially 3 levels of scrutiny that the government can enforce. One is what's known as rational basis. You think of it as the minimum level. Essentially, if they can come up with any reason whatsoever, even hypothetical, then it survives. Then there's what's known as intermediate scrutiny, and then strict scrutiny. When it comes to the type of restrictions that the government's implementing, say content-based restrictions, they don't have many mechanisms to essentially squash what would be an unpopular opinion. That's what's known as having content-based restrictions, speech restrictions. Now, strict scrutiny, which is the highest level of scrutiny, is very hard for the government to overcome. There's essentially very, very few instances where they can say the government can deny your content. It's one of the great things, if not the greatest thing, about the first 10 amendments is, by and large, the government can't censor speech, even if it doesn't like the message. And specifically, if it doesn't like the message and it says so, that has particular extra levels of protection in the United States. Generally speaking, the free speech clause provides that the government has no power to restrict expressions of its message or ideas. The court's precedent allows the government to constitutionally impose reasonable time, place, manner regulations. However, when you look at these type of regulations, there is, so the government has essentially degraded its own content based in favor of speech for collecting government debt. So essentially what they're saying is our content is okay in a robocall fashion, but someone else's isn't. So the essential argument by the plaintiffs is, in this matter, we're being treated unequally. That is, the government is treating us in a manner that is not consistent with the First Amendment. That's generally how this case got to be before the court. The government doesn't draw a distinction based on the speakers, is an argument that they presented at trial. Essentially what happened is the government said, we have a compelling governmental interest in order to bring this case, not to bring this case forward, but we've appealed this case in order to get a ruling in our favor because we have a compelling governmental interest in gathering these debts. 6 members of the court concluded that the Congress impermissibly favored debt collection speech over political and other forms of speech in violation of the First Amendment. Now, there was a concurring in part and dissenting in part from Judge Gorsuch, which I'll talk about here in a second. Essentially, what happened is the plurality of the court came and said, yes, this is a violation of the First Amendment in that it is content-based restrictions. We're saying that robocalls for debt purposes are not restricted, but for political purposes are restricted. And that therefore leads to an inequitable outcome in which certain forms of content, i.e. political speech, is being sanctioned and or is being oppressed, and that governmental speech to collect the debt is not. It's being treated differently. And that inconsistency is therefore incompatible with the First Amendment in the United States, which I think is a pretty predictable outcome. There is a concurring opinion by Judge Sotomayor that states that because this is in commerce, it doesn't actually have to do with the interchange of ideas, that this is not the same as someone going out on the square giving free speech, that these political action groups or these political groups trying to solicit donations is not part and parcel the same as individual rights of speech. I think that's problematic for a couple of reasons. Number one, you have the ability for these strong institutions to have massive amounts of speech. And so we have to have a very forceful look at what's happening with this type of speech in the manner in which it's being prescribed. Number two, when we're looking to these type of cases, essentially what we're trying to determine is whether or not this entire legislative scheme is constitutional. That is, back in 1991, there were several tens of millions of robocalls being made. And from a policy perspective, we have to weigh policy analyses within the construct of our constitutional backdrops. So we have the First Amendment framework that tells us that Congress shall make no law impeding free speech. And then we have to deal with the reality that there is no right that's so absolute that it can infringe on rights of other people. Most Americans, if not, in upwards of 90%, would probably say that they don't want to have robocalls made to their cell phones. In fact, I can't say that I've ever met a person who would say that they would enjoy those things, other than maybe to just kind of torment someone who's calling them. But again, if it's just a pre-recorded message, most people would prefer not to have that happen on their cell phones. I know I, for one, would prefer that some random institution not be calling me night and day any time of the week in order to try and solicit information, whether it be for robocalling and collecting of a debt or robocalling in seeking political finance contributions. And essentially that has been upheld, and we reached this 2015 carve out in which Congress has essentially exempted themselves and said, well, we want to not abide by these rules. The actual review from the case is actually authored by Judge Kavanaugh, and in his review, I think he actually does a really good job of pointing out what's happening. So essentially, what's happened is this political action group is not actually upset by the fact that the government has this exemption and that their speech is occurring. They're upset by they can't enact the same speech. So they come to a crossroad as to what is the ultimate remedy going to be in this case. And there's what's known as the doctrine of severability. So what the doctrine of severability is, it essentially says if one part of, because legislation is often hundreds, if not thousands of pages long. For instance, the Affordable Care Act was over 900 pages long. So severability is essentially an explicit written construct in the bills that say, if one portion of this, one section is deemed unconstitutional, the rest of it remains in effect. It essentially becomes, it essentially is like if you had it, A, B, and C, and you find out that subsection C is unconstitutional, you essentially draw a line through it. It would no longer be valid. That's the severability doctrine. We're severing the particular part that is not constitutional while leaving the overarching framework in place of the law and remaining constitutional in this matter. And that's really where there's a disagreement between Kavanaugh and Judge Gorsuch. Judge Gorsuch would essentially have abrogated the entire law. And so there's a long historical precedent as to why that shouldn't be the case. Essentially, for policy reasons, the court has said that we have a preferred choice in severability. That is, we're going to not try and do what's known as sideline legislation or judicial legislation, that is, craft new laws or eliminate entire statutory schemes because one minor subsection is proving to be inconsistent or unconstitutional. And really, I think that's an important ruling that came out the right way. If Judge Gorsuch's view had been the predominant view, robocalls, as of the time of publication and enter of the final order to the lower courts, would have been legal for all purposes. You can imagine that since 1991, the tools and efficacy to be able to bring about robocalls have only expanded. I think that we would see an exponential growth in automatic robocalls from all kinds of, our private information is packaged and sold. That's how major tech companies, including Facebook and YouTube, make some of their profits, is being able to sell and package this private data. And so once your private cell phone makes it into a database, is sold, you'd be getting massive amounts of robocalls at any time of day without limitation, because the entire statutory scheme would be deemed unconstitutional. And so I think that we have, in this case, a case that, had it gone the other way, would have had huge implications. I think the courts got it right in this case, in which you have inconsistent carve out. And so I always want to, at the end of these cases, I want to just talk about, what are three big takeaways from the cases. Number one would be that robocalls in all forms are nearly completely illegal. They're still illegal. So if you're getting robocalls, and you can identify the company that's doing the robotic calls, pre-recorded calls to your cell phone, you should probably contact an attorney. There are statutory fines and penalties for companies that do that. So if you're getting these calls, you might have legal grounds. Number two, government cannot favor content speech, even when they are the actors. So even when it's the government making the speech, they don't have preferential treatment. They essentially have to treat everyone fairly under the First Amendment restrictions. And so this statute essentially survives strict scrutiny. They have a compelling governmental interest for consumer privacy. You and I have individual privacy in our cell phones, our privacy and constitutional rights not to be disturbed in our persons. And therefore, companies cannot violate our individual rights in the name of First Amendment free speech, right? These corporations can't buy our information and then harass us based on that information under the guise of free speech. And I think that's the correct outcome in this particular case. Number three, severability means we essentially draw a line through the unconstitutional sections and leave in place the remainder of the law. Really, what you have is every rule has an exemption on this. And kind of just a little bonus here in the concurring opinions, Justice Breyer actually would have asked for overruling of many of the old previous issues, but that would kind of fly in the face of what we refer to as stare decisis, which is essentially leaving matters settled. The court doesn't like to disrupt age-old legal principles unless they have a compelling reason to do so, and in this case, they did not find one. So that concludes the kind of overlooked case that came out this week. So let's go ahead and transition now into one that hits home here for us Washingtonians, Shafalo et al. Versus Washington. Now, when Americans cast ballots for presidential candidates, their votes actually go towards selecting members of the Electoral College. So this case is what's often referred to as the faithless electors case. And each state appoints these electors based on popular returns. States have devised mechanisms to ensure that the electors that they appoint vote for presidential candidates that their citizens prefer. So essentially, who you vote for in the popular vote is the person who's supposed to be the individual that is voted for, that essentially receives the vote in tandem with the electoral vote in order to have a majority vote of the Electoral College. So essentially, the states prescribe a process in order to which we all go to the ballots. In Washington, we have mail-in ballots, which I think are actually extremely effective. It's a felony to falsify that, and the falsification rate is astronomically low, near zero. And so the states have to essentially have a mechanism in order to compel electors to get their vote. Now, most states compel electors to pledge to support a nominee of that party. Relevant here is that there are 15 states that back up their statutory scheme with some sort of sanction. Almost all of these states immediately removed the so-called faithless elector from his position, submitting an alternative whose vote of the state reports in line with the way that the state votes are supposed to go. Washington also imposes a monetary fine for any elector who flouts his pledge. In the specific Chafalo case, there were 3 Washington electors, Peter Chafalo, Levi Guerrera, and Esther John, the electors that violated their pledge to support Hillary Clinton in the 2016 presidential election. In response, the state fined the electors $1,000 apiece for breaking their pledges to support the same candidate its voters had. The electors challenged their fine to state court, arguing that the Constitution gives the members of the Electoral College the right to vote however they please. The Washington Superior Court rejected that claim, and the state Supreme Court affirmed, relying on Ray v. Blair. Now, Ray v. Blair was a previous case that essentially had upheld the pledge requirement, though one without penalty to back it up. So the new question was whether or not this monetary sanction was enforceable. So the holding in this case was that a state may enforce an elector's pledge to support his party's nominee, and the state voters' choice for president. This case specifically has to deal with constitutional principles and principles within the amendment itself, namely Article 2, Section 1, which gives the states the authority to appoint electors in such a manner as the legislature thereof may direct. The Supreme Court has described that clause as conveying the broadest powers of determination over who can become an elector. And the power to appoint an elector includes the power to condition his appointment absent some other constitutional constraint. A state can require, for example, that an elector live in the state or qualify as a regular voter during that time period. So we have Article 2, Section 1 of the United States Constitution, which is extremely short. It's brief, and it has been interpreted to convey extremely broad powers to the state in order to implement the mechanisms in which these electors vote. A state can insist that the elector pledge to cast his electoral college ballot for his party's presidential nominee, thus tracking the state's popular vote. And that happens in over 30 states in the United States. And as of now, actually 32 states and the District of Columbia have such statutes on their books. And what's most relevant is that the states began over 60 years ago to back up their pledges with these laws with some kind of sanction. And by now, 15 have statutory sanctions, with monetary penalties, which have been upheld in the interim essentially have not been successfully challenged. And this was actually a consideration that I had thought about previously as, what is the purpose of the Electoral College? And the history here for our complete legal nerds is actually really interesting, at least from my perspective. I find it very interesting. So the historical note, and this is quoted from the case, is that in the dying days of summer, they, the founding fathers, referred this matter to the so-called Committee of 11 to devise a solution. The committee returned with a proposal for an electoral college. Just 2 days later, the delegates accepted the recommendation with but a few tweaks. James Madison later wrote to a friend that the difficulty of finding an unacceptable selection process was deeply felt by the convention. That was in his letter to G. Hay, 1823. Because the final arrangement took place in the latter stage of the session, Madison continued, it was not exempt from a degree of the hurrying influence produced by fatigue and impatience in all such bodies, though the degree of which much less usually prevails in them. Because there was a question for me about, when you look to the Federalist Papers, there's the Hamiltonian consideration that these individuals that occupied the electors would be of such character and prowess that they would have the intellectual capacities to make sure that they would be making the right decisions. However, one of the big things here is where the written rules have to deal with the actual pragmatism and history of the Constitution and what the actual expectations of the populace are. So one great thing that I read is essentially says begin at the beginning. With the nation's first contested election in 1796, would-be electors declared themselves for one party or the other presidential candidates. Recall that in this election, Adams led the Federalists against Jefferson's Republicans. In some states, legislatures chose the electors and others ordinary voters did. But in either case, the elector's declaration of support for a candidate, essentially a pledge, was what mattered. Or said differently, the selectors of an elector knew just what they were getting, not someone who would deliberate in good Hamiltonian fashion, but someone who would vote for their party's candidate. There's even a footnote where one disgruntled individual wrote in saying, I didn't tell you to vote for, or I didn't elect you to go and make up your mind. I elected you to go and vote for whom we chose as to be our candidate. The great thing that I think is that comes about this is comes from one of the dissents. So it concurs in the result, but the dissent essentially comes in and says that the structural principle is explicitly enshrined in the 10th Amendment. And the 10th Amendment states that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. And I think that's a really important, the 10th Amendment often gets overlooked, which is a reservation of powers to the people. And in this particular case, the argument was essentially, Article 2 doesn't say enough. Article 2 is not what gives the states the power, which I think there's plenty of room to agree to disagree on that one. I think that when you look to the actual language and the historical precedents, I think there's a fair argument to be had that that there is support for these type of actions, and it hasn't been successfully challenged, and that it grants broad authority. But I actually prefer the dissenting analysis, which says that you're reading too much into these sections our answer is actually in the 10th Amendment, which I think is true in many of the cases, is we have to look to the federal government as a government of enumerated and limited powers, reserving to the states and to the people the ultimate rules of power. And I think that gets us to the correct analytical analysis that we want from a constitutional perspective in perpetuity. So not just for this particular case, but as a backdrop to future cases that might be more complex. So my big takeaways, the three big takeaways from this case are: one, the Constitution grants large general authorities in picking electors. Two, monetary penalties are enforceable should they be faithless. That's the question that was unanswered. And three, really just to say that history and pragmatism matter, that in these type of cases, the courts aren't completely blind or completely directed by history, but also by what the societal expectations have been and what they are currently. And I think that this is also a case that was well decided, and I think that the dissent actually provides the hopefully useful framework going forward in cases that could present similar issues. All right, so that's our faithless electors case. Nothing too earth-shattering about that, but it has a lot of really interesting historical context to it. So let's move on to the next case, which is... Sorry, I have my video feed looking off to the side, just making sure there's not any comments coming in. Okay, so the next case that we're going to look at is the Our Lady of Guadalupe case. And this case, before we get started, and I'm just going to be completely bold and honest about it, is one that likely is one of the most polarizing cases that has come out. I think even more so than the tax cases that we'll talk about here in a minute. This has to do with, actually, no, this isn't the case. The next case is. So this case is the Our Lady of Guadalupe. As a practitioner, I would say is the most unremarkable case that has come out. I've seen some reporting on it, but as someone who has done significant amounts of employment law, particularly almost exactly these type of cases, employment law is a battlefield within a landmine, within an intergalactic war of epic proportions. It is extremely challenging, and I've taken cases to trial in federal court, and they're bloodbaths, and they really are exhausting. And if you're facing problems in your employment and you feel like you've been discriminated against, I know that nothing else is more personal to people than their work product. They take pride in their work. Some people live entirely for their work, and it's very hard and very difficult. But all I can say from a pragmatic point of view, and I tell many of my clients this, is trying to seek justice in an employment discrimination case is literally going to be the death of you. It's one of those things where even if you can prove your case, even if you were to win, the emotional, physical, psychological toll it's going to take on you is going to be very damaging. And the court has what's known as a mitigation of damages principle. So let's say you've been at your job for 20 years. You have an obligation to go out and seek a similarly situated job. Not just take the first job that comes along. If it pays half or whatever, you have to seek a job similarly and exhaustively. And even then, there's going to be a cap on the amount of future damages that you're going to get. In short, it is very hard to be made whole whenever you're involved in employment matters. So with that backdrop, I don't want to discount or try to belittle. In fact, I feel it more personally than almost anyone, having seen people have just devastating individual losses or individual hardships through their work or former employers. I definitely understand, but just statistically speaking, the numbers, the last time I had a CLE a couple of years ago at the federal level was essentially 73% of all federal discrimination cases are dismissed at summary judgment. And all summary judgment is it's way before the trial, right? Months and months in advance. They say, hey, they don't have enough evidence to support a lawful claim, and here's why. And nearly 75% of the time, the courts agree with defendants, that is, the employers. So just with that backdrop, that's important to know as we go into Our Lady of Guadalupe School versus Morrissey. This case has to do with First Amendment protections and religious freedom for institutions to, quote, decide for themselves, free from state interference, matters of church, government, as well as those of faith and doctrine. There is a previous ruling that set out a framework, Hassan-Tabor. It's known as the Hassan-Tabor test, also known as the ministerial exemption. That was essentially expanded in this case. So the First Amendment barred a court from entertaining an employment discrimination claim brought by an elementary school, Cheryl Parish, against the religious school where she taught. Adopting the so-called ministerial exception to laws governing the employment relationship or religious institution and certain key employees, the court found relevant the title of Minister of Religion, and stated that her education, training, and her responsibilities to teach religion and participate with students in religious activities. In the current case, the two elementary school teachers at Roman Catholic schools in the Archdiocese of Los Angeles had teaching responsibilities. Both were employed under nearly identical agreements and set out the school's mission to develop and promote Catholic school family faith community, imposed commitments regarding religious instructions. They were required to comply with school faculty handbooks, which set out similar expectations. Each taught in a religious classroom, worshiped with students, prayed with students, and had their performance measured on a religious basis. Both teachers sued their schools after their employment was terminated. Both claimed that they were fired or demoted and failed to renew their contract and were placed with younger teachers in violation of the Age and Employment Discrimination Act, as well as the American with Disabilities Act for the other plaintiff. They were able to obtain summary judgment with the ministerial exception at the lower court, but the Ninth Circuit reversed, reasoning that they lacked the credentials, religious training, and ministerial background. Ultimately, the holding was that the First Amendment's religious clauses foreclosed the adjudication of both of these employment discrimination claims. The independence of religious institutions in matters of faith and doctrine is closely linked to independence in what the court has termed matters of church government. For this reason, courts are bound to stay out of the employment disputes involving those holding certain important positions with the church and other religious institutions. When the ministerial exception reached the court looked to the precedent in the background against the First Amendment was adopted and unanimously recognized that the religion clauses foreclosed certain employment discrimination claims brought against religious organizations. From a moral perspective, this is one that I don't think that sits well with many individuals in the legal community who see people who are wrongfully terminated and who commit themselves to a faith and religion and then ultimately have that religion turned upside down and used against them for essentially any justification for their termination. One of these plaintiffs had breast cancer. I think that ultimately ended up to be terminal, and believed that was a legitimate reason why they were fired. But even if they weren't in the religious context, again, we still have that overarching principle that you essentially have to prove that the substantial factor was the discriminatory purpose, and employers, as long as they're keeping good documentation, can support their positions of terminating almost anyone. Again, almost every single state is what's known as an at-will employee state. So they can fire you for any reason, no reason at all, as long as it's not primarily for discriminatory purposes or intent. And primarily is the key. They could even admit that, say, yeah, we discriminated against her, but that's not the primary reason. There were A, B, and C reasons In these type of cases, they could say that they didn't follow the catechism properly, that they failed to meet reasonable expectations in the job. And so even if they were discriminatory, if you as a plaintiff can't prove that it was a substantial factor in your firing or termination or non-renewal of contract, you still lose. And so from a practitioner's perspective, this is a case that emotionally is difficult for me to deal with, because it brings up a lot of memories of other cases that I've dealt with where people have seemed really harmed. And even once we settle and think that you've had a good outcome, they just, they're never quite made whole. And so this is one where we have the ministerial exception being expanded. And I think one thing that it is clear to say is that this does not mean that religious institutions enjoy a general immunity from secular law, but it does, according to the court, protect their autonomy with respect to internal management decisions that are essential to the institution's central mission. And a component of that autonomy is the selection of the individual who play certain key roles. The, quote, ministerial exception was based on this insight. Under this rule, courts are bound to stay out of the employment disputes involving those holding certain important positions with churches and other religious institutions. The rules appear to have acquired the label ministerial exception because the individuals involved in pioneering cases were described as ministers. The thing that they go into about this is that, the Ninth Circuit essentially made an error when it tried to rigidly apply the factors that were addressed in the previous case. So moving forward, if you work for a religious institution, I think it's fair to say you will likely fall under the ministerial exception. To me, this case significantly expanded the breadth of the ministerial exception and proves that there's no direct formula. It's going to be, what you do and what the record's going to show and prove. And so, the big takeaways, the three from this one are: one, as I stated at the beginning, employment cases are exceedingly difficult, very, very difficult. Most are dismissed at summary judgment, as I previously stated. Two, religious exemptions have now been extended. So if you work in these fields, you have to know that if you're discriminated against, likely there will not be a redressive grievance, at least at the federal government level. And even under the Washington law against discrimination, the federal supremacy clause is probably going to override any added protections that you might have. And number three, if you feel like you're being discriminated against at any point, these cases are built on documentation. So document. Make a record, file HR complaints, send emails to supervisors. If your supervisor is harassing you, go to the supervisor above them. If they're unresponsive, go to the head of the company. If they're unresponsive, go to anyone in human resources. If everyone's unresponsive, go to the media, go to whatever you can do in order to make public records of things that are happening. Without explicit and clear documentation, many, if not most, discrimination cases, even if they're completely legitimate, and many of them are, can oftentimes be dead on arrival. So sorry, I don't have any positive outlooks on that. I'm a bit jaded from that line of work. I think it's important work. It needs to be done, but it's very difficult and oftentimes not fruitful. Sometimes it is, and sometimes people are made whole, but oftentimes that's not the case. So moving on, now we'll get into the, I would say, most contentious version or most contentious case that's come out, which is the Little Sisters of Poor Saints Peter and Paul Home versus Pennsylvania. And this case, I think, if I were to say that it were unexpected, I don't think that's true. I think this one was, it makes sense when you understand the technical legal backgrounds of what's going on. So this has to do with whether or not public and private employers under the Affordable Care Act have to provide contraception. And actually, in many ways, that question has already been previously answered under the Hobby Lobby case. So for me, it's really important to do some objective background on the Hobby Lobby case. So Hobby Lobby essentially filed what's known as a RFRA claim I had in law school. Both of these issues are Religious Freedom Restoration Act and the APA, Administrative Procedure Act, are directly things that I started the entirety of my legal career with. And if you ever need anything that's going to help put you to sleep or make you drowsy, pick anything in the Administrative Procedure Act and your eyes will be closing in a matter of moments. However, that being the case, they're really important to understand the ongoings of what's happening in this case. So we have the Patient and Protection Affordable Care Act, better known as Obamacare, even though it originally was a Republican derivation that came from Mitt Romney's home state and was modified and changed. And so why it was adopted as a formal plan by the Obama administration is beyond the scope of this discussion, but all I will say is that briefly, it's something that is the state of the current law and is was on arrival going to be an insufficient mechanism to address the exponentially growing cost of healthcare in this country. If you looked at premiums before the Affordable Care Act, it is objectively true that they were already trending upwards significantly, and that in some ways this has mitigated some of those costs in certain areas, and in many ways it has inflated many of those costs. And the biggest issue has to do with law and economics, which is actually a subject that I wrote my jurisprudential capstone thesis on. And the shortest basic overview that I can give you is there's a principle in the economic sphere, which is known as, it's actually taught in basic economics, but its application is far-reaching, which has to do with price elasticity, which if that's not already putting you to sleep, then you're definitely more powerful in having a long concentration than most human beings, particularly all those who took my economic courses other than myself. But essentially what price elasticity measures is a responsiveness to change. So by way of example, if I were to give you an apple and an orange, these are what are known as substitute products, and I said, here's an apple, it's $12, and here's an orange, it's 12 cents. Well, almost everyone's going to choose the orange, no matter how much you love apples, because you would say, well, apples, $12 for an apple is a ridiculous price. I don't need an apple because I have an orange right next to it, which will give me similar nutrients and is similarly going to satiate my desires. When it comes to healthcare, we don't have the same kind of bargaining power because oftentimes there are no substitute goods. We don't have the ability to bargain, and therefore we don't have a true marketplace in which we can exert downward forces through competition, which is what markets are actually pretty good at doing in limited respects. And there are also many, many market failures, which is healthcare is considered objectively in the economic literature as an area of market failure, particularly when it comes to prices of like the United States pays the highest per capita for all of our pharmaceutical products than any other country. And it's been proven that almost none of that has to do with research and development, and it has everything to do with price elasticity and the marketing and our ability to not get them from other countries and import them. So with that kind of philosophical and economic backdrop, we have the Affordable Care Act, in which It passes in 2010 and almost immediately goes into litigation because there's a requirement. It requires covered employers to provide women with, quote, preventative care and screenings without, quote, any cost sharing requirements, and relies on preventative care guidelines supported by the Health Resource and Services Administration, also known as the HRSA, to determine what preventative care and screenings includes. The citation on that's 42 USC section 300 GG 13A4, for those who really care, which is no one. Those guidelines mandate that health plans provide coverage for all Food and Drug Administration approved contraceptive methods. When the Department of Health and Human Services, Labor, and Treasury Departments incorporated the guidelines, they also gave HRSA, that's the administration, the discretion to exempt religious employers, such as churches, from providing contraceptive coverage. Now, again, it's a deeply religious and political issue on whether or not contraceptions should be granted. The scientific point that I would bring up here, which absolutely has to be noted, is contraceptions are, of course, a misnomer. All they are is a chemical pill that you take that have certain implications for the human body. One of those implications is that it can prevent women from essentially producing their ovum, and that's only one of its utilizations. There are many women who have to take, quote, contraceptions for non-contraceptive reasons. It has to do with their own personal private health, cramping. Some women, it could be nearly fatal for them to not have these particular, and again, there's broad characterizations, and this is far-reaching as far as its implications, because it makes no the way that the regulations and the litigation has borne out is it's not making those kind of detailed it's not making the detailed dissection of which individual types of contraceptives are and are not being covered. Essentially, what happens is these corporations can make a declaration that says, we believe in good faith that we don't have to provide contraception. And that's it. There's not a back and forth as to, well, these are medically necessary and therefore should be covered, even though they might have a byproduct. Your employee has a legitimate need. Where again we get back into the privacy issues of how much your employer should know about your personal private health information. My position is that they should have nearly zero access to that information, because we have a constitutional right and individual liberty to not be personally assuaged by any individual health problems that we might have, or have any kind of outward influence by our employers based on our health consequences, as long as they don't influence our work. That's, of course, my position, and I think it would be a shared, likely in the libertarian sentiment, and that, my individual actions aren't the concern of the government or my employers. But I also think that, the government is one of the only, and at least in many other countries, that actually have high functioning governments that can act on the well-being of their populace. I always think about Japan. Japan does an excellent job of providing very cheap and inexpensive healthcare to over 140 million people on their island. So I always advocate that I want what Japan has, but that's perhaps more of a political argument and not just a legal basis. But when we're looking to the guidelines in this particular case, we essentially have religious entities that challenge the rule under RFRA, the Religious Freedom Restoration Act. And it was previously stated that the contraceptive mandate substantially burdened the free exercise of closely held corporations with sincerely held religious objectives, or objections to providing their employees with certain methods of contraception. It's imperative, I think, to note that the clear conflict of interest, like Hobby Lobby, does not serve as the poster child for this case. And in fact, I think for the religious community, they're one of the worst case scenarios, because it turns out, as a matter of public record, that Hobby Lobby largely invested in the same methods of contraception through third parties. They essentially had a stake in many of these pharmaceutical corporations that administer these. And I think that it's objectively true that Hobby Lobby was just trying to cut their costs any way that they could, which for people who, as capitalists, that's what the entire purpose of corporations are, which is to cut their costs. And oftentimes it's the government's jobs to step in and regulate them in ways that we as society agree align with the betterment of all society. So I think there's a bit disingenuous for Hobby Lobby to make those claims. But being that as it may, the law has determined that the contraception mandate is a substantial burden on free exercise of religion. So this case is not new in that it continues to it essentially does not reach the religious freedom restoration question, but reserves the answer to that question and states that the true question is whether or not the exemptions that came following the Hobby Lobby case were lawfully enacted. So the government essentially expanded the type of exemptions for both private and public corporations, including churches, in order to deny the contraception coverage. And the ultimate ruling in this case is that the departments requested the proper backdrops and information needed under the Administrative Procedure Act. So essentially the APA states you have to follow certain procedures in order to administratively enact certain policies. The government determined that the APA was properly followed, which I think is the correct determination. That doesn't presuppose the previous discussion of whether or not we as a society should agree that this is the wrong or right thing to do. But we're all worried about what is in the law. So we're just trying to determine what the law is. And the law currently as it stands is that there is no exemption from the Religious Freedom Restoration Act, even though Congress could write one into it and say, hey, religious freedom is supremely important, but contraception is also supremely important because it has other life-saving properties and other important properties for health and well-being. And we also have an overriding concern of constitutional privacy, and therefore Religious Freedom Restoration Act is overruled or not exempt from the Affordable Care Act. Congress could easily write that legislation, and this opinion upholds that fact that Congress could change federal law in order to properly impose the religious freedom or essentially circumvent the religious freedom restoration burden. They could explicitly write it into the law as such. The court stated that on its face, the provisions under the ACA granted sweeping authority to HRSA to craft and set standards defining the preventative care that applicable health plans must cover. But the statute is completely silent as to what those comprehensive guidelines must contain or how HRSA must go about creating them. The statute does not, as Congress has done in other statutes, provide an exhaustive or illustrative list of the preventative care and screenings that must be included. It does not, as Congress did elsewhere in the same section of the ACA, set forth any criterion or standards that the HRSA selections should be made. It does not, as Congress has done in other contexts, require the HRSA to consult with or refrain from consulting with any party in the formulation of the guidelines. So our big takeaways from this case are essentially the lack of specificity leads to these kinds of outcomes. The congressional intent could have been explicit. They could have provided the exact type of care that was going to be required. They could have set out the framework in which these regulations would be promulgated. They could have made extremely limited exemptions. They could have exempted the Religious Freedom Restoration Act. They could have changed the Religious Freedom Restoration Act. They could still change the Affordable Care Act. They could do a lot of things, but they didn't do them. And if Congress didn't do them, the courts, which is a good thing, are not going to be reading in and legislating because that's not what the courts do. The courts don't draft legislation. They interpret and determine whether or not it is in line with our Constitution or conflicts with other laws. The second big takeaway is that it's difficult in these type of cases to combat a claim for good faith belief. So essentially all you have to say is, I believe in good faith that I shouldn't have to provide contraception. And it doesn't seem that evidence to the contrary will be very persuasive once you make that declaration. So we have to be very careful in allowing these type of good faith belief exemptions without specifics. Like, do I think that small churches in rural towns should be forced to pay for contraception? Perhaps not. Perhaps that does, in fact, violate the First Amendment. I can't say that I'm sure one way or the other because every case is fact specific, and I don't know if the individuals have life-threatening ailments that would require them to take them. Again, it's a dirty and messy business trying to make these determinations, and why they should largely be left to the individuals, not some legislature that has no nuanced understanding of personal individuals' healthcare needs, the beliefs and interactions between employers and employees and the greater society, and whether or not people can actually afford these life-saving drugs on their own. They're very complicated questions, and clearly the current legislative paradigm has not been well addressed in dealing with them, either directly or through the exemptions. So it is a difficult subject. It will continue to be a difficult and polarizing subject. I hope that science and reason can overtake them, and that individual liberties can be upheld on all fronts, including the actual legitimate religious beliefs that I think are undermined by major corporations and for-profit corporations claiming these exemptions to cut costs. I think it really undermines the position of people who really have these true and ardent beliefs, particularly these institutions that have been around as long as the Union, or much longer than any of the actual legislation that's been around. So I will leave it at that for this one, and we will move on to, let's see, where are we at? Where are we at? I will leave that on to the next one. So the next one is the one that probably most people, if you're tuning into this, if anybody ever tunes into this, would be waiting for, which are the Trump tax return cases. And I'll have to say that I actually am not too surprised at the outcomes of these, nor am I surprised at the judicial reasoning. So Trump versus Vance. This has to do with the state of New York and the Trump tax returns. In 2019, the New York County District Attorney's Office, acting on behalf of a grand jury, served a subpoena duces tecum, which is essentially just a formal request to produce documents on Mazaris USA LLP, the personal accounting firm of President Donald J. Trump. For financial records relating to the president and his businesses. The president, acting in his personal capacity, sued the district attorney and Mazaris in federal district court to enjoin the enforcement of the subpoena, essentially saying you can't do that, arguing that a sitting president enjoys, quote, absolute immunity from state criminal process under Article 2 and the Supremacy Clause. The district court dismissed the case under the abstention doctrine of Younger v. Harris, and in the alternative held that the president was not entitled to injunctive relief. The Second Circuit rejected the district court's dismissal under Younger, but agreed with the court's denial of injunctive relief, concluding that presidential immunity did not bar enforcement of the subpoena, and rejecting the argument that the United States, as amicus curiae, which just means friend of the court, that a state grand jury subpoena seeking the president's documents must satisfy a heightened showing of need. The holding in this case was that the Supremacy Clause did not categorically preclude or require a heightened standard for the issuance of a state criminal subpoena to a sitting president. And I think everyone has to rejoice at this outcome, except perhaps the president himself, because the thing that we definitely don't want in this country is someone who is above and beyond the courts and the law. Um, it's the entire founding of this country is that we are not a dictatorial, tyrannical monarchy. We don't have royalty in this country. And whether it's you or me or any of the previous presidents, that there is no one who is above the law. So in this has a history literally as old, almost from time immemorial of this country. In 1807, John Marshall, presiding as Circuit Justice for Virginia over the treason trial of Aaron Burr, granted Burr's motion for subpoena ducis tecum directed at President Jefferson. In rejecting the prosecution's argument that a president was not subject to such a subpoena, Marshall held that a president does not, quote, stand exempt from the Sixth Amendment's guarantee that the accused have a compulsory process for obtaining witnesses for their defense. Sole argument for an exemption was that a president's duties as chief magistrate demand his whole time for national objects. But in Marshall's assessment, those duties were not unremitting, and any conflict would be addressed by the court upon return of the subpoena. Marshall also concluded that the Sixth Amendment's guarantee extended to the production of papers. The property of introducing any papers, he explained, would depend on the character of the paper, not the character of the person who holds it, and would have due consideration upon the subpoena. And again, Jefferson ultimately turned over this information upon the prerogative that was determined the particular executive communications would be withheld as long as they were subject to national security interests. So for this case, I think it's really important to know what they're asking for. This is a state criminal investigation in which they're asking for financial records in which they have submitted to on behalf of a grand jury. In the 2 centuries since Burr, successive presidents from Monroe to Clinton have accepted Marshall's ruling that the executive is subject to subpoena and have uniformly agreed to testify when called in criminal proceedings. In 1974, the question whether to compel the discourse of official communications over the president's objections came to a head when the Watergate special prosecutor secured a subpoena ducis tecum directing President Nixon to produce, among other things, tapes, recordings, in the Oval Office meetings. The Supreme Court rejected Nixon's claim of an absolute privilege of confidentiality for all presidential communications, recognizing that, quote, compulsory processes was imperative for both the prosecution and the defense. The court held that presidents' generalized assertions of privilege must yield to the demonstrated specific needs for evidence in a pending criminal trial. Even Nixon dutifully released the tapes. The history all involved federal criminal proceedings. The president, and I agree, the president does actually have unique duties as head of the executive branch, which come with protections that safeguard his ability to perform his vital functions. The Constitution also guarantees the entire independence of the general government from the control by the respective states. And I think that those principles are good to be reminded of. I think those are the appropriate responses to have when it comes to seeking certain information. But again, it's about the character of the information that's being sought. Almost all of the documents are being sought before a time in which he was the sitting president. So they're not information that's currently relevant to him in office. They're not asking for private communications with foreign leaders, which is one of the chief, if not the chief goal constitutionally of the president, is to deal with foreign dignitaries. In addition to signing and enacting and enforcing laws, again, they're not asking for information that would give him any kind of frustration in his ability to execute the laws. To the contrary, if people have faith that the president of the United States is on the up and up with his financial records, I think that it gives more credibility to the going administration, something that they probably are in a strong need of these days. One of the arguments the president claimed is that the state criminal subpoenas necessarily pose a unique threat of impairment and thus require absolute immunity. His categorical arguments focuses on three burdens: diversion, stigma, and harassment. Well, if diversion, stigma, and harassment are a threat to the presidential office, it's probably time for him to give up his Twitter. I mean, I can't go on without saying that. I mean, it's just, there's nothing more divisive in our world right now than what's going on in the Twitter sphere and social media. So if those are the three pillars in which he's mounting a defense, I think the court was right to reject them. And the court did. The court expressly rejected immunity based on distraction alone 15 years ago, alone 15 years later in Clinton v. Jones, when President Clinton sought absolute immunity from civil liability for private acts. As the court explained, Fitzgerald's dominant concern was not mere distraction, but distortion of the executive decision-making process. So again, there's historical precedent from the Clinton administration in which he's not being unduly treated, because the courts have held consistently that that type of embarrassment or distraction is not the overriding concern, especially when it has to do with a state criminal investigation for things that happened while he was not in office. We can have a different discussion on whether or not you think the president in any way can be prosecuted for the things that he does while in office, but that's a different question. It's literally not the question being asked. The president claims that his case is different. He believes that he is under investigation and argues that the toll will unnecessarily be heavier in this circumstance. But the president is not seeking immunity from the diversion occasioned by the prospect of future criminal liability. He concedes that he may be investigated while in office. So even his office concedes that. His objection is instead that the limited additional distraction caused by the subpoena itself. That argument, however, runs up against the 200 years of precedent establishing that presidents and their current officials and communications are subject to judicial process, even when the president is under investigation. That was determined in Nixon. The court essentially goes through and rejects all three of those propositions, saying that it makes him an easily identifiable target for harassment. The court rejected a nearly identical argument in Clinton, concluding that the risk posed by harassing civil litigation was not serious because federal courts have the tools to deter and dismiss vexatious lawsuits. Essentially, the current system has check backs against these type of claims. Harassing state criminal subpoenas could, under certain circumstances, threaten the independence or effectiveness of the executive. But here, again, the law already seeks to protect against such abuse. First, grand juries are prohibited from engaging in arbitrary fishing expeditions or initiating investigations out of malice or intent to harass. So that argument has already gone by the wayside because this determination on behalf of the grand jury has already been granted. And federal courts may intervene in state proceedings that are motivated by or conducted in bad faith. Second, because the Supremacy Clause prohibits state judges and prosecutors from interfering with the president's official duties, any effort to manipulate a president's policy decisions or to retaliate against a president for official acts through issuance of subpoena would be an unconstitutional attempt to, quote, influence a superior sovereign exempt from such obstacles. That was dating back to McCulloch v. Maryland. And federal law allows the president to channel any such allegedly unconstitutional influence in a federal forum. So essentially, there are already significant legal checkbacks against these type of, quote, vexatious litigations that are happening against the president that would not have been brought in good faith. This is seen as not that instance, and in fact is seen as exactly the opposite. The court rejected a heightened standard and does not leave the president without recourse. The president may avail himself of the same protections available to every other citizen, including the right to challenge a subpoena on any grounds permitted by state law, which usually include bad faith, undue burden, or breadth. It comes back to analyzing what is being asked for. In this particular case, we're asking for private, personal financial documents from his business enterprises that have been directly attributed to a valid criminal investigation. Such information is absolutely necessary for the administration of justice. And as someone who's occupying the highest executive branch, who is in charge of executing the laws of the United States faithfully, pursuant to his oath of the United States Constitution, it behooves anyone to have any kind of efficacy or individual legitimacy in that particular office to cooperate with these type of investigations, or even if not cooperate, he can avail himself of the, as just stated, all of the individual tools that all the rest of us have in order to resist this. But ultimately, even if he's not cooperative, which he doesn't necessarily have to directly cooperate with, because he's Donald Trump and he's going to do whatever he wants to do, that's really what got him elected. At the end of the day, if an impartial grand jury or a court determines that this information is necessary in order to determine either his guilt or innocence, or the guilt or innocence of anyone he's been associated with or affiliated with, or is being charged in association or affiliation with, then the Sixth Amendment, as well as state and local regulations and constitutions, are still applicable. And, really, there is no exemption when it comes to these type of requirements. So the big takeaways here are, number one, no one is above the law, not even the sitting president that has over 200 years of precedent in the United States, and I think is really important for all of us to know that there is no one who is above the law. Number two, that the character of the subpoena matters. I don't think the president should have to disclose private communications that could have to deal with potential international terrorism, potential deals with foreign dignitaries, things that are generally subject to presidential privilege. I think all of those things do have their appropriate place, and I think it's not appropriate to cry foul just because they're invoked by Donald Trump himself under the right context. So really you have to do a case-by-case analysis, and the court looked at this one and said that it's not appropriate to withhold this information from the state criminal investigation. So that leads us well into our next case, which is, as we in the biz like to do, is be distinguishable. I'm going to take a quick water break right now because I'm really thirsty. I've been talking for an hour and 16 minutes straight at a high rate of speed, I'm certain. It's all my years of competitive debate, so I apologize to anyone if I've been speaking too quickly. I try to moderate myself, but I have a naturally quick speaking pattern, and I don't like having pauses and the ums and stuff, so I'm either really slow or really fast to try and compensate for those. So I apologize, but let's go ahead and move on to the next case, which is Donald Trump versus Mazaris USA, which you might recognize from the previous case, which is his private accounting firm. And again, this is where the subject and the issuance of the subpoena are important. A little bit of informational background. In April of 2019, 3 committees of the U.S. House of Representatives issued 4 subpoenas seeking information about the finances of President Donald J. Trump, his children, and affiliated businesses. The House Committee on Financial Services issued a subpoena to Deutsche Bank seeking any documents related to account activity, due diligence, foreign transactions, business statements, debt schedules, statements of net worth, tax returns, and suspicious activities identified by Deutsche Bank. It issued a second subpoena to Capital One for similar information. The Permanent Select Committee on Intelligence issued a subpoena to Deutsche Bank that mirrored the subpoena issued by the Financial Services Committee, and the House Committee on Oversight Reform issued a subpoena to the president's personal accounting firm, Mazaris USA, LLP, demanding information related to the president and several affiliated businesses. So I think it's really important to look at the timing and character of the information that's being sought. So we have a criminal investigation at a state level, which is upheld as constitutionally permissive. And simultaneously, we have the House of Representatives asking for nearly the same information. Now, while the court doesn't explicitly draw the linearity between what's going on here, it's hard to believe that they're not taking that into consideration. And I think there is an allusion here to it in their writing. In both cases, petitioner contends that the subpoena lacked a legitimate legislative purpose and violated the separation of powers. The president did not, however, argue that any of the requested records were protected by executive privilege. In Mazaris, the district court granted judgment for the House, and the D.C. Circuit affirmed, finding that the subpoena issued by the Oversight Committee served a valid legislative purpose because the requested information was relevant to reforming financial disclosure requirements by presidents and presidential candidates. In Deutsche Bank, the district court denied a preliminary injunction, and the Second Circuit affirmed in substantial part, holding that the Intelligence Committee properly issued a subpoena to Deutsche Bank as part of the investigation into the alleged foreign influence in U.S. political processes, which could inform legislation to strengthen national security and combat foreign meddling. The court also concluded that the subpoenas issued by the Financial Services Committee to Deutsche Bank and Capital One were adequately related to potential legislation on laundering, terrorist financing, global movement of illicit funds through the real estate market. So the holding for this case, the courts below did not take adequate account on the significant separation of powers concerns implicated by congressional subpoenas for the president's information. Now that's an interesting holding. They essentially said that the previous court did not give due consideration. So what does that mean? Like, what does that mean for the disposition of this case? Because if you were to read this case, you might question about what happened. Like that seems like a non-answer, right? Like what does that mean? Where does that leave us in what I think people consider an important question? And it is an important question. Does Congress have the authority to subpoena these documents? That's an important question. And what the court essentially did is they punted, right? They punted the ball down the field, metaphysically speaking, to a time later. And I have to note that the proximity in which this case is coming out in relation to the November elections, I don't think is dubious, but I think it is relevant. I think it specifically points to the court's, there's a doctrine which is known as, it was referred to previously in one way, which is known as the abstention doctrine, but there's also what's known as non-justiciable political questions. It's a weird word. Probably haven't heard it very often, but it essentially says there are certain questions that are of such a political nature that we, that is the 9 justices of the Supreme Court, do not like to delve into political matters. We are not a political instrument, right? We're not elected, we're appointed. We're appointed to lifetime appointments. That way we can be free from the political foyer, at least in theory, though if you look historically and statistically, that may not be true. But that's at least the idea, is that certain times there are certain political questions, and though they don't expressly state it in this case, they really are running into their predisposition to not want to delve into matters of a extreme political nature. So here they state, historically, disputes over congressional demands for presidential documents have been resolved by the political branches through negotiation and compromise without involving this court. So first they look to history and say, look, there has been a lot of contention in the past. Like the last 200 years have been crazy. This whole notion that we're more polarized than ever, nonsense. You guys can work this out. That's at least what they're hinting at here. The court recognizes that this dispute is the first of its kind to reach the court, that such disputes can raise important issues concerning relations between the branches. that similar disputes recur on a regular basis, including in the context of deeply partisan controversy, and that Congress and the executive have nonetheless managed for 2 centuries to resolve these disputes among themselves without Supreme Court guidance. Such long-standing practice is, quote, a consideration of great weight in cases concerning the allocation and power between the 2 elected branches of government, and what it imposes on the court is a duty to ensure that it does not needlessly disturb the compromises and working arrangements reached by those branches. Each house of Congress has the power to quote, secure needed information in order to legislate. That's McGrain v. Daughtry. The power is indispensable because without information, Congress would be unable to legislate wisely or effectively. Because this power is justified solely as an adjunct to the legislative process, it is subject to several limitations. Most importantly, a congressional subpoena is only valid if it is related to and in furtherance of a legitimate task of the Congress. The subpoena must serve a valid legislative purpose. Furthermore, Congress may not issue a subpoena for the purpose of, quote, law enforcement, because that power is assigned to the executive and the judiciary. Finally, recipients of congressional subpoenas retain their constitutional rights and various privileges throughout the course of the investigation. The big thing here is the court went on to state that neither side identifies an approach that adequately accounts for those weighty separation of power concerns. A balanced approach is necessary one that takes a considerable impression from the practice of government, the pressures inherent within each of the separate branches to exceed the outer limits of its power, in assessing whether a subpoena directed at the president's personal information is related to the furtherance of a legitimate task of Congress. Courts must take adequate account of the separation of powers principles at stake, including both the significant legislative interests of Congress and the unique position of the president. Several special considerations inform this analysis. First, courts should carefully assess whether the asserted legislative purpose warrants the significant step of involving the president and his papers. Occasions for constitutional confrontation between the 2 branches should be avoided whenever possible, said the court. Congress may not rely on the president's information when it has other sources that would be reasonably able to provide Congress the information it needs in light of its particular legislative object. Second, to narrow the scope of the possible conflict between the branches, courts should insist on a subpoena no broader than reasonably necessary to support Congress's legislative objective. The specificity of the subpoena request serves as a, quote, important safeguard against unnecessary intrusion into the operation of the president. Third, courts should be attentive to the nature of the evidence offered by Congress to establish the subpoena. The more detailed and substantial, the better. This is particularly true when Congress contemplates legislation that raises sensitive constitutional issues, such as legislation concerning the presidency. Fourth, courts should assess the burdens imposed on the president by a subpoena, particularly because they stem from a rival political branch that has an ongoing relationship with the president and incentives to subpoena for institutional advantage. This case was vacated and remanded. There's a really pedantic thing that happens that at the end of the main opinion, it says the judgments of the courts of appeals for the D.C. Circuit and the Second Circuit are vacated and the cases are remanded for further proceedings consistent with this opinion. So I took a federal courts course while I was in law school, and I think the textbook was about this thick. And pretty sure we read all of it and like 10 things supplemental to it. And there was an interesting conversation that we had is when they write sometimes not inconsistent with this ruling or consistent with this opinion. And we had a big, long discussion about whether or not those two terms have any differing legal implications. I think I ultimately settled on it doesn't really matter, and not just due to exhaustion, but I think that that it doesn't really matter is a formal legal evaluation. But really, I bring that up because it begs a question as to where I started earlier: is where does it leave us? What does it mean? What really happened here? So what happened is the court came into it, examined the record, examined the filings at the lower court, because the higher courts are limited by the record in which is presented to them. And both the record of the writings of the plaintiffs, the defendants, and the court rulings, right? The courts will look at to what the judges at the lower levels have written and what they based and what they made their considerations on. So like when I go to court and let's say a case reaches the end, what'll happen is the courts will make a finding of fact and conclusions of law. So I present my side of the argument, my opposition presents their side of the argument, and the court comes in and says, I think you're right, I think you're wrong, or I think you're both wrong, or I think you're partially right and you're partially right, and here's why. And so that formulates a part of a formal record that the lower courts are that thus by and large presenting to the upper courts. And oftentimes judges know this. They know that, okay, this case is going to make it to review. So I either want to be specific or I want to be general or some combination. And I have specific findings of facts and conclusions of law. And so here the court looked at the record, looked at the argumentation, looked at the history and said, hey, we really don't like treading into these waters. But if we are going to tread into these waters, we need a more substantiated record as to what's going on, right? Part of this should be contextualized is this also all happened in tandem with the special counsel Mueller investigation that was going on. And again, whether you agree with the investigation or not, objective facts are the investigation produced 37 indictments, 7 guilty pleas, compelling evidence that the president obstructed justice on multiple occasions, 14 criminal matters. A statement signed by over 1,000 formal federal prosecutors concluded that if any American engaged in the same efforts to impede federal proceedings the way Trump did, that they would likely be indicted for multiple charges of obstruction. So Trump comes out and labels these things a witch hunt. And in certain respects, he's vindicated. And in certain respects, there's real questions about whether impropriety was happening. And so you have this kind of political turmoil and backdrop against these separate questions, right? So if you're trying to discern why was this information disclosed in a criminal prosecution, well, there are very specific constitutional requirements that are extended in the criminal investigation versus what's happening in this case. And that leads me into the big takeaways for this case. And here's something that's interesting. There is no explicit constitutional device granting power to the United States Congress to subpoena, right? That's what was stated earlier, is essentially this is an ancillary power, right? Like the courts have acknowledged that the importance of legislating is of such a high regard that of course they should have access to some kind of subpoena, but there are limits. And there are additional limits than in like a criminal investigation, right? Congress doesn't do criminal investigations. They don't execute the laws. That's not what Congress does. Congress legislates. They write the laws. They send it to the executive to be signed, and then once it passes and is formalized, then they execute the laws, right? They are the ones who execute the laws. So you have this balance of the separation of powers in which the court takes a historical note and says, hey, there's usually a political process and it usually takes a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. The Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation, the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation, the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time. And I think one of the fairest criticisms of the impeachment and the Mueller investigation took a long time But the impeachment process happened in very short order. It did seem very rushed when it happened, which is why, if it was ever going to be successful, which it likely wasn't, and that's mainly the Democrats' fault based on what happened in the Clinton administration, based on historical precedent and party lines. That's just a matter of fact. It's just one of those things where the Democrats made a bed with the Clintons back in the 90s, and now they had to lay in it. I thought that there was essentially a 0%, 0.0000, as near infinity of 0.01% as you can get. The numbers are simply the Republicans controlled the Senate, and they were never going to vote to impeach no matter what. But particularly when the process was rushed and seen as unbiased and unfair, which were definitely legitimate criticisms of the current establishment. You think you have all of this backdrop where the court looks to it and says, "Hey, you guys, in the court of law, we don't rush these things." I always say that to my clients: is the gears of justice grind very slowly. It's an unfortunate byproduct, but it's also how due process happens, right? It takes a long time, and it's frustrating, and it's expensive. And it's an inefficient system, but we have been unable to devise a better one, right? That's just the long and short of it. And so the court looks to this and says, all right, at the lower levels, we have an investigation against Donald Trump, and it's coming from a body that doesn't have explicit investigatory powers, so we have to limit it. And in the legal field, we have what's known as an exhaustion of administrative remedies. And here, essentially, Congress didn't exhaust their administrative remedies. They didn't exhaust the ability to get this information from other sources. They didn't exhaust the political, normal, historical process that happens. And so on the record, based at the lower courts, they come in and say, hey, we don't think that the lower courts gave enough consideration to what happened, to this question of separation of powers. And therefore, we are remanding, which means to send back down for further proceedings for something that's consistent with this opinion, right? So that's a big, long, drawn-out way to say we have more to do here. There's more work to be done before we ever actually answer this question. And it goes back to, it's also a convenient way for the court, unsurprisingly, to actually delay the hard issue, right? They don't actually have to make the hard choice now, several months away from a extremely contentious and numerically close presidential run. So those are kind of the big takeaways. And the third takeaway is you have to exhaust your administrative remedies. You have to do everything you can before you go to the courts to try and get this information. And once you go to the courts and prove, look, Judge, we tried to do it the old way. We tried to do it the historical way, and it just didn't work. That's what it seems like the court was looking for in this case. And because of the character and nature of who's asking and what they're asking for in the backdrop of all those political ramifications of things that are going on, I think that's why you see two very different outcomes on these two cases. And I think it makes sense. I don't think that... I think the historical argument carries actually a lot of weight here. I think that it is ultimately overcome by just how polarizing and where we're at politically, but there just wasn't enough proper work done at the earlier proceedings to force the Supreme Court to have to make the hard decision. And that happens a lot. That's very predictable. That's something that we in the legal field know that they're going to try to avoid the hard questions if they can find any way to do so. And so here, there's more work to be done if we're ever to get an answer to the hard question. And I don't know that we ever will. But that's what is actually happening in that case. So it's not an ultimate win for either side. It's a punting of the ball in a very technical sense down the road. All right. We are at an hour and 38 minutes. I'm definitely going to try and keep this under 2 hours. But we are delving into McGirt versus Oklahoma, which is something that's very close and near and dear to my heart. Not only because I grew up in Oklahoma. I grew up in Houston until I was 15, at which point my family was largely, we were evicted from our home, and I was essentially living out on the streets, homeless. And then my aunt and uncle took me in, who lived in Oklahoma, and so I finished high school and went to college in Oklahoma. And I lived in Tulsa for a couple of years. I worked there, and I'm actually going to visit Oklahoma soon. So McGirt versus Oklahoma is a case that has to do with the Major Crimes Act, which provides that within the Indian country, quote, Indian country, any Indian who commits certain enumerated offenses shall be subject to the same law and penalties as all other persons committing any of those offenses within the exclusive jurisdiction of the United States, 18 U.S.C. 1153. Subsection A, Indian country includes all the land within the limits of any reservation under the jurisdiction of the United States government. Section 1151. Petitioner Jim C. McGirt was convicted by an Oklahoma state court of 3 serious sexual offenses. He unsuccessfully argued in state post-conviction proceedings that the state lacked jurisdiction to prosecute him because he is an enrolled member of the Seminole Nation, and his crimes took place on the Creek Reservation. He seeks a new trial, which he contends must take place in federal court. Held. For MCA purposes, land reserved for the Creek Nation since the 19th century remains Indian country. Now that is just a remarkable ruling, especially given the historical nature of Supreme Court rulings. And in fact, this is an argument that I made when I was in Washington as a National All-American debater my final year. We talked about the historical precedents when it comes to the treatment of Native Americans. And we would often refer back to the Cherokee Nation's case. And in that case, which in many ways has been overturned and abrogated, but it still pervades as a framing. It presents the framing of the Native American question of sovereignty in the United States. And in that case, for the first time, as far as we can tell in human history, the sovereignty of the Native Americans was characterized as a, quote, dependent sovereign nation. Dependent, not independent. They're not separate, but they are a dependent sovereign nation, somehow inexorably dependent on the United States of America. And that has such pervasive and long-standing implications on how we as a society have interacted with the Native American community. Native Americans have the highest rate of alcoholism. They have the highest suicide rates. They have the highest per capita lack of literacy rates. Most reservations don't have potable water. They have some of the, especially in Oklahoma, they have some of the worst cases of leachings of hexavalent chromium into their water, which is a known carcinogen. There's just all kinds of implications historically that have channeled from that type of ruling. And so for the Supreme Court to come in and make this ruling is rather profound. It's an acknowledgement to the one of the 2 original sins in the United States that we're still dealing with. One, of course, being chattel slavery, and number 2 is the seizure and essentially the acculturation of natives, in which we tried to bring them into what's seen as the Western or white culture. and disavow their own individual identities. Going back to my the first drafting I ever had to make that dealt, as previously I was talking about, with the Religious Freedom Restoration Act, we actually had to do writings on the Northern Arapaho tribe and the Eastern Shoshone tribe, who were historically mortal enemies. They have essentially diametrically opposed religious beliefs when it comes to things like the American eagle. So in the cases when I was in law school, we had to draft. It was a real case that was going on that we were doing for simulated purposes. That had to do with an eagle take. So essentially the sacrificial killing of an eagle, which was necessary for one tribe and completely offensive to the other tribe. And you had to balance their religious freedoms and whether or not the permitting process could happen on the one reservation that they shared. And so this kind of plight between these two tribes is really encapsulated in the entire history of the literal hundreds of Native American tribes that used to occupy this land, which were forcibly taken off of their land, promised reservations in some of the worst areas in the United States, up until valuable resources, sometimes decades or even hundreds of years later, were found, particularly in Oklahoma with their shale oil, have largely been disenfranchised and underserved, and it's a continuing problem that our country faces and will always have to deal with. And this just creates a whole new dynamic as far as where we go in treating Native Americans in this context. So a little more about the case. Congress established a reservation for the Creek Nation. An 1833 treaty fixed borders for a, quote, permanent home to the whole Creek Nation of Indians, and promised that the United States would grant a patent in fee simple. That just means in total, or essentially means without encumbrance, right? So if I give you a plot of land and I say in fee simple, it means kind of without restriction. It's just a legalese term. In fee O to A for life, in fee simple absolute, as my now retired property professor would say. He'd also say railroads. To the Creek Nation of Indians for the assigned land to continue so long as they shall exist as a nation and to continue to occupy the country hereby assigned to them. The patent formally issued in 1852. Though the early treaties did not refer to the Creek lands as a, quote, reservation, similar language in treaties from the same era has been held sufficient to create a reservation. And later acts of Congress referring to, quote, the Creek Reservation leave no room for doubt. Congress has since broken more than a few promises to the tribe. God, isn't that the truth? Nevertheless, the Creek Reservation persists today. Once a federal reservation is established, only Congress can diminish or disestablish it. Doing so requires a clear expression of congressional intent. Oklahoma claims that Congress ended the Creek Reservation during the so-called allotment era, a period when Congress sought to pressure many tribes to abandon their communal lifestyles and parcel their lands into smaller lots owned by individual tribal members, which has been a huge and terrible policy called fractionation of the land, which has just had just abysmal. And I mean, the idea is we give everyone their own plot, and that's going to give them an agency, but it's had almost the inverse effect. Missing from the allotment era agreement with the Creek, however, is any statute evincing anything like the present and total surrender of all tribal interests in the affected lands. And this court has already rejected the argument that allotments automatically ended reservations. Oklahoma points to other ways Congress intruded on the Creek's promised right to self-governance during the allotment era, including abolishing the Creek's tribal courts and requiring presidential approval for tribal ordinances. But these laws fall short of eliminating all tribal interest in the contested lands. Oklahoma ultimately claims that historical practice and demographics are enough by themselves to prove disestablishment, which is a terrible argument to be making, right? Their whole position is predicated on, we've treated them so terribly that you should just give us the rest of their land. I don't know how that could be any more offensive to anyone who has, for anyone who believes in personal property ownership. Even historically, if you don't give them complete sovereignty, you have to say, okay, we allotted you this land, and now it's forfeited because we have failed to continue to give you and accede to your rights, right? Like, it's like if this were a criminal case and it's like, we failed to give you any and all constitutional protections. You didn't have right to counsel. You didn't have a due process. And because we've treated you so poorly, you get to remain guilty and in jail for life. And not only just in life, but the life of your children and your children's children in perpetuity. I mean, it's just, it's a morally repugnant argument to be making, honestly. I mean, and maybe it's the only legal argument that they had available. But as with many cases of how we've treated Native Americans, it's really not a good argument. The Supreme Court has consulted contemporaneous usages, customs, and practices, and to the extent they shed light on the meaning of ambiguous statutory terms. But Oklahoma points to no ambiguous language in any of the relevant statutes that could plausibly be read as an act of secession. Such extra-textual considerations are limited interpretive value and are least compelling form of evidence. In the end, Oklahoma resorts to the state's long historical practice of prosecuting Indians in state courts for serious crimes on the contested lands, various statements made during the allotment era, and the speedy and persistent movement of white settlers into the area, also known as Sooners. But these supply little help with the law's meaning and such potential mischief. And again, this is the kind of argument that the Fourth Amendment often runs into. So the Fourth Amendment in the United States guarantees protection from unlawful search and seizures. The problem with the Fourth Amendment is that it's mostly criminals that invoke it, and so there are often exceptions that are found. But it's still a fundamental right. It is a convention of the United States that is as important as the First Amendment, as the Second Amendment. I mean, it is a constitutional amendment for a reason. And so here you have all of these historical examples as to say, well, we've already done it. But that doesn't cure the legal issue here. In the alternative, Oklahoma contends that Congress never established a reservation, but instead created a, quote, dependent Indian community. There's that language again. To hold that the Creek never had a reservation would require willful blindness to the statutory language and belief that the land patent to the Creek received somehow made their tribal sovereignty easier to divest. Congress established a reservation, not a dependent Indian community for the Creek Nation. Even assuming the Creek land is a reservation, Oklahoma argues that the MCA has never applied in eastern Oklahoma. It claims that the Oklahoma Enabling Act, which transferred all non-federal cases pending the territorial courts to Oklahoma state courts, made the state courts the successor to the federal territories courts' sweeping authority to try Indians for crimes committed on reservations. That argument, however, rests on state prosecutorial practices that defy the MCA rather than on the law's plain terms. Finally, Oklahoma warns of potential consequences that will follow a ruling against it, such as unsettling an untold number of convictions and frustrating the state's ability to prosecute crimes in the future. This court is aware of the potential for cost and conflict around jurisdictional boundaries, but Oklahoma and its tribes have proven time and again that they can work successfully together as partners, and Congress remains free to supplement its statutory directives about the lands in questions at any time. That last statement is highly questionable, and I know many people in the community that would not agree with such a statement. So Judge Gorsuch wrote this one. But I do have to say the opening is actually pretty powerful. And so I do want to read that briefly. On the far end of the Trail of Tears was a promise. Forced to leave their ancestral lands in Georgia and Alabama, the Creek Nation received assurances that their new land in the West would be secure forever. In exchange for ceding all their land east of the Mississippi River, the U.S. government agreed by treaty that the Creek County west of the Mississippi shall be solemnly guaranteed to the Creek Indians. Treaty with the Creeks, Arts the 1st, March 1832, the Treaty of 1832. Both parties settled on boundary lines for a new and permanent home to the whole Creek Nation, located in what is now called Oklahoma. Treaty with the Creeks, Preamble, 1833. The government further promised that no treaty or territory shall ever have a right to pass laws for the federal government of such Indians, but they shall be allowed to govern themselves. Treaty of 1832. Today we are asked whether the land these treaties promised remains an Indian reservation for purposes of federal criminal law. Because Congress has not said otherwise, we hold the government to its word. Things that I didn't think that the Supreme Court would ever say. I really didn't think that. There's such a historical, they embrace it, right? The state of Oklahoma embraced the argumentation that we've treated them so poorly, you should just do the what is politically easiest by letting us continue to prosecute them in our state courts, even if it defies both the federal government, the federal law, MCA, the historical precedents on international law, our treaties, and our federal determinations. And again, this case involves someone who's a terrible person who should probably spend the rest of his life in jail. He was sentenced to 1,000 years in jail. And I hope he spends every bit of that in jail. I believe is on rape of a small child. And, the question is it implicates questions that are bigger and more important than this one terrible and heinous human being, which goes back to my Fourth Amendment analysis, where the Fourth Amendment is important for all of us. It's important, we continually see that the government is doing wireless search taps and, listening in on this conversation and any pre-recorded conversations without a warrant. And that violates all of our rights. And it's those kind of communal rights that we have to continue to reassert on behalf of criminals. So when they try to wrongfully prosecute anyone else in our society, that information stays out of the courtroom. That information is, we call it the fruit of the poisonous tree. Essentially, when the government does something illegal, we need to have a remedy against them. And one of those remedies is that information is inadmissible in any court of law. And so too here we have an individual who doesn't deserve, he is not deserving of a new trial for the acts that he did. He deserves a new trial because the law requires it. Due process and our constitutional foundations, in which all of the edifice in which all of our society is built upon, is constitutional law. And at any point we try to circumvent the Constitution for brevity's sake, we're jeopardizing everything that we've ever worked for. All of the incremental changes, and we have many, many more to make, all of that is at risk when we start doing what is morally expedient as opposed to morally necessary. And that's really what this case finally has gotten to in the state of Oklahoma, is that they've made a decision that is morally necessary in the face of what is morally expedient. And there's so much going on about the future implications that I could spend a whole nother 2 hours just talking about this one case and what I think the future implications are going to be. But I think you got a really good overview as to what has happened, and that there's been now a fundamental shift in determination about them being an established sovereign nation. And but I think it's also important to contextualize it as this is limited right now to the facts of this case, which has to do with the criminal context, right? We're not talking about just civil ownership and what that means for people occupying those lands there today. That's not a question that was addressed. But this question will lay the foundation for new questions going forward. So, and I have lots of them. lots and lots of questions as to where this is going to leave us jurisprudentially, where it's going to leave the state of Oklahoma in their ability to actually prosecute these cases. How are they going to prosecute these cases? How many people are going to be filing appeals? It's going to be a lot. There's going to be a lot of especially Native Americans who are going to be trying to seek expungements, and that has implications for tolling and due process in federal court and on the Indian nations. And it's really a difficult but socially interesting question around a very difficult and hard subject that our country has to look face on. By hiding our heads in the sand is not going to solve these problems. And it's good that the Supreme Court made the difficult but correct decision in this case. Will they continue to do so remains to be seen. As we've seen in these cases, there's been a lot of inconsistency. So really, I just wanted to present. I did the work to read through, 400 or 500 pages worth of Supreme Court cases this week. And so I wanted to present an overview and a condensing down this information. And for Shannon, who's probably the only one who tuned in, and if anyone else takes a look at this, I hope that it gives you a more in-depth, because you see kind of clips online of, that you can read in 1 minute or 2 minutes, and they don't really get into what these cases mean, what was actually decided. And not that I did that 100%, but I think that I hopefully help provide a little more context into these important decisions, what they mean, and why we should pay attention to them. The Supreme Court is issuing new decisions every month, and it's important for people to have access and know what's going on both in our government and in the Supreme Court decisions, so we have a better understanding of how our legal process works. I think that's good for everyone. And so here at the Late Night Legal Process, or Late Night Legal Podcast, remember that justice never sleeps. And I try to sleep now and again. But thanks for anyone who tuned in. I don't know if I'll do this again. It's good to produce content when I did the prerequisite work anyway, just kind of as part of my job. So I like to double dip on that front. Hopefully, maybe I'll publish something in writing coming out in the future. So stay tuned on that. I have a lot of ideas. And if we have another Blockbuster week and Supreme Court decisions all at the same time, maybe I'll do another one of these. And so thank you for tuning in. And if at any point anyone ever needs official legal advice, I do mostly civil work, first-time criminal offenses. I've done some employment law, but I'm very choosy about the cases that I take. I do estate planning, wills, any kind of general civil matters. So if anyone who needs an attorney, I practice in Washington, but I am applying for reciprocity in other states in ongoing ventures. So if anyone needs an attorney, just reach out to me at latenightlegal@gmail.com, or you can give me a call and leave me a voicemail and I'll get back to you. My phone number is 253-656-4475. Thank you for tuning in to the Late Night Podcast.